Hello, hello. Y'all, we're just going to go over a couple of things today. We're going to go over a couple of things today. What we are going on, breaking news, breaking news. We have the new petition from the Blake Lively and versus Justin Baldoni case. Somebody wants out. They want to be free. And we'll discuss it after this. Good morning, good afternoon, good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture, along with celebrity legal news. Listen, today, this is going to have to count as my weekly Lively and Baldoni news because, baby, I'm breaking today. Looks like Ryan Reynolds is trying to get up out this lawsuit. I guess his SNL skit didn't roll over with the people good. I guess we found out too in regards to the Glamour magazine, and I'm gonna watch one of the young ladies that is covering this case that I just love her take. I am going to play her video. It's about 5 or 6. It's about 5 or 6 minutes. We're gonna play her video because she has discovered that Miss Glamour magazine. There's a really close relationship going on with that. All right. I would say she is reporting that she did give credit to the internet sleuths, the mommy sleuths, whoever trying to be the lady trying to be funny about those of us that are out here reporting the information, and we're getting the court information, and we're making assessments of those things, and she's trying to make a mockery of the things that we're doing. But I want to go over her video real quick, and then we will continue on. Let me get over here to YouTube. And while I'm doing that, y'all hit that like button. And please share this video into your social medias. I'd really appreciate that. Here we go. Give me one moment. I'm gonna crank her up because this is what I'm gonna say. Now, if you're not familiar with what I am talking about, last week, Stephanie McNeil, I think is what her name is, wrote an article in regards to this Blake Lively. Clearly, the article was very Blake Lively leaning, and that's not a problem. But the issue came in is that she had, in my opinion, she had some elitist type attitudes about the women. She specifically mentioned women. She had some very elitist attitudes about the women who are covering this case. Now, there are men and women covering this case. Justin Baldoni versus Blake Lively, Blake Lively versus Baldoni, and them suing the other parties. So there's a lot of people out here covering this place, but she seemed to zoom in on quote unquote mommy sleuths, and she was trying to make some kind of argument that they're not part of, I'm paraphrasing and I'm just pulling my opinion. It seemed like she was trying to make it like Blake Lively is a woman, and so therefore you're supposed to be on the side of the woman, and that you're being a mommy and sleuthing. You're not part of the womanhood and all this other stuff. It was just a whole lot of stuff. And like I said, I glanced at the article. I didn't read a whole lot of it, but baby, I can tell you that the end results of all of that is that people were up in arms, and they were so up in arms. I think she privated her IG account. You can read the article. You can go definitely on IG, not IG, glamour.com, and you can read that article. Hi there, Mr. Wizard. Yes, honey, she closed down that Joker. So I wanted to go over real quickly this young lady's video. Now, on all her platforms, she goes by Bohemian Diva. I'm going to have her information down in the description box below. Go cover her on, because I mostly follow her on TikTok, but go follow her on TikTok, and she's also on this platform as well. So let's go over really quick what Bohemian Diva had to say about Miss Stephanie. Blows my mind. All right.
Hi, Stephanie. How are you? My name is Marie. I go by Bohemian Diva on all of my social media platforms. You don't know me, and I really don't give a shit about you. But I noticed that 3 days ago, when you decided to wage war on my TikTok colleagues, primarily the female content creators, and just reduce them to merely mommy sleuths, you pissed off a lot of people. And members of my tribe did a little digging. And there's a very specific reason why you wrote that shitty ass article trying to paint.
Balake.
My, oh my, oh my, what a paper trail you left. Is this you? Your husband is Brian Henry.
And let me just stop it right here. If the cursing bothers you or anything like that, I apologize. I just have to let people be how they be. But also, she uses code words. So Balake is, just think of the person who has a first name with a B, and then she says the Christopher Columbus of Hollywood. That is who Balake is married to. So we'll let you continue.
Mm, mm. Wow, talk about 3 degrees of Kevin Bacon. I see he is fighting for his life in them comment sections trying to defend you, and he made his Instagram private because, that heat and that smoke got a little too intense.
Oh, Lord.
Stephanie. One thing you do not do is go up against the internet. You will always lose every single time. Because one thing you and your husband underestimated is the internet's ability to research and dig for anything and find anything. Remember the 3 degrees of Kevin Bacon? Because that's how many degrees it took to connect the dots. Your husband, degree number one, is the senior producer for a television show, Sell It Like Sirhan on Bravo, created in 2018. hmm Why does Ryan Serhant matter?
Listen.
Because he sold Bradley Cooper's house. Degree number two, Bradley Cooper happens to be friends with our favorite Hollywood DL bottom, Christopher Columbus of Hollywood.
Surprise, surprise. Surprise, surprise.
And since your television show facilitated the sale of Bradley Cooper's childhood home, who happens to be friends with Christopher Columbus of Hollywood, that in turn brokered a deal to host this little project.
Tell her, Boo Boo Kitty. I'm she. Oh, now you can't speak English.
Interesting, Stephanie, how everything came full circle. Your husband is the senior producer of Sell It Like Sahant. Ryan Sahant sold Bradley Cooper's childhood home. Bradley Cooper just happens to be longtime friends with Christopher Columbus of Hollywood, who happens to be married to,
Balake.
which in turn led you to write that piece of shit ass article for Glamour magazine. 3 degrees of Kevin Bacon.
Oh my goodness. Shout out to Bohemian Diva, because she broke that down in her little lovely little way how she talks. I have a good time watching her. She's she has a way of being able to put out her ideas, and she stands in her stuff, and I love that. I love that. So again, I will put her description. She's on YouTube. It's Bohemian Diva. She's on TikTok. All social medias that she's on Bohemian Diva. So basically, I'll just recap what she said. Miss Stephanie McNeil's husband is a producer on this show, Sell It Like Sarant. They were the ones that sold Bradley Cooper's home. Bradley Cooper is friends with Ryan Reynolds. So she's putting pieces to piece together as to why that article was Blake Lively friendly. But I'm going to tell it to y'all like this. If they spend all that money for Special Agent Shapiro, whatever his name is, he needs to give them their money back. Because this don't make no sense. Because it shouldn't be to the point. It shouldn't be to the point that the internet sleuths, the social media sleuths, can find this information out and know whose camp this is. Oh, child. I couldn't. There is no way in the world that I could write a script like this. This is absolute craziness. This is absolute craziness. So let me get you all here to show you what I am talking about. Let's see. All right, so let me share my screen real quick. So you all have asked, because here it is. Here it is the question. And yes, Ryan Reynolds has decided that he wants to be relieved from the lawsuit. Oh, I hate when it does that. Where did you go? Anyway, so here it is. This is just the notice, the motion, but there is a whole amended complaint, and we'll definitely get into that. But here it is. It says, notice of defendant Ryan Reynolds' motion to dismiss the amended complaint and for related relief. Defendant Ryan Reynolds hereby moves to dismiss the amended complaint with prejudice and without leave pursuant to federal rules of civil procedures, blah, 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 blah. In support of this motion, Mr. Reynolds respectfully submits the accompanying memorandum of law, and we'll go over that. But I skipped over the blah, blah, blahs. Moves to strike Exhibit A to the amended complaint pursuant to federal of civil procedure, and moves for an award of attorney fees pursuant to New York civil rights law. Well, I don't think y'all saw that, did y'all? Hold on. Here it is. Here it is. I apologize. Because now you got to do some extra clicks in order for you to say, when you used to just be able to click it and keep it moving. But here is his notice for the motion of dismissal and dismissal. Ryan Reynolds wants to get out of this case. Child, he is leaving Mo Blake in the doggone wind. He said, no. I guess number one, his little SNL skit, so that where he's used to making people laugh, and he's been able to pull you in with his laughter and his boy next door charms and his quirkiness. No, that's not working. Folks are not even paying him any attention like that. Number two, CIA agent has been striking, in my opinion, been striking out, been doing all of this stuff by trying to get content creators pages or videos taken down, reporting different, doing a whole lot of stuff which you think would work. They're also working on manipulating the internet searches via Wikipedia, so that when you search certain things, they can manipulate what comes at the top of the search screen. they're doing all of this stuff, and like I said, that's what a crisis PR team is supposed to be doing. But I guess it's not working fast enough for Ryan. Ryan probably wants to get out here and make some more money, and it's people are not wanting to be bothered with him. So he's seen that this is what he believes to be the problem, because he supported Blake until he's not going to support her anymore in regards to this. I'm not saying that he's leaving his wife or anything like that. I am saying that he is not willing to no longer stand in solidarity. And it could be a smart move. Maybe he wants to maybe he thinks that they could separate and then it won't be such a big hit if they get if they ended up having to pay or anything like that. I am not sure, but let's go ahead and let me stop sharing this. And let me get rid of that. Ooh. There. Now let's put up what we need to say. So I child, he's like, sayonara, girl. You know, love you, but I ain't finna be here with you. And plus, I honestly think that there's some questions that he don't want to answer because they have not gone through discovery yet. I think that there's questions and things that he doesn't want to answer, which is fine. I'm just saying. Let me get this together. Okay. Give me one moment, y'all. So it's about 38 pages. So we are definitely going to go over these little 38 pages. That'll get us at an hour. All right. Is that the one I want? I think that's it. I don't know. Let me see if I can change this real quick. I apologize, y'all. It's just that these that's the problem. I already figured it out. Give me 1 second, y'all. Let me stop sharing. Because I was trying to figure out why it wasn't as big on the screen as I like for it to be. Slight technical difficulties. And while I'm doing this, y'all hit that like button. I appreciate y'all holding for little old me. I got so tickled and being tickled. There we go. Ah, took a minute. All right. Here we go. So here is his filing. Oh no. Wait a minute. What? Who's Hugh? Hugh Jackman? I'm gonna let that go. So here we have memorandum of law in support of defendant Ryan Reynolds motions to dismiss the amended complaint. So here are, look at all the attorneys. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. He has 11 attorneys. And I saw something interesting about this attorney right here, this Michael Gottlieb. Apparently, Michael Gottlieb is the attorney for Drake. And Melissa Nathan is the PR person for Drake. So this is interesting that these two are working with the client together, and then he is part of a situation where he is suing her. That is quite interesting, isn't it? But anyway, let's get down here. This is a lot of attorneys. Here are the tables of contents. Claims against Mr. Reynolds fail under both New York and California law. The court should dismiss all 6 causes of actions as to Mr. Reynolds' prejudice. And we are going to go through all of this. We are going to read all of this. These are all the laws that they are going to be quoting in this. Okay, so that tells me this is not going to be that long, because they've already went through 7 pages of stuff. The introduction. Blake Lively sued Jamie Heath, Justin Baldoni. It Ends With Us Movie LLC, Jennifer Abel, Melissa Nathan, Wayfarer Studios, and Steven Sarowitz after they collectively launched a retaliatory, quote, social manipulation campaign to destroy and bury her because she privately spoke up about the SH in inappropriate conduct that she and others experienced on the set of the film It Ends With Us. So what does Ryan Reynolds have to do with that? Legally speaking, other than being a supportive spouse who has witnessed firsthand the emotional, reputational, and financial devastation Miss Lively has suffered? Nothing. Mr. Reynolds is a defendant in this action for one reason and one reason only. Because billionaire plaintiff Steve Sarowitz promised to spend up to $100 million to, quote, ruin, end quote, Miss Lively and Mr. Reynolds. The First Amendment complaint that Sarowitz and his co-plaintiffs filed seeks to fulfill that promise by polluting this court's docket with hundreds of paragraphs of clickbait designed for an audience other than this court, with virtually no bearing on cognizable legal claims. I'm gonna have to go back and see that. I'm gonna have to see what she says. Ooh. Okay, I'm gonna have to go back over that way and see. No, I'm not a follower of hers, but when it comes to this case, I'll definitely jump in and see it, because my issue with her and Megyn Kelly and all of those people like that is, their party has basically won, so they don't have anything else to talk about. They're not talking about the stuff that's going on in their party, which is always amazing to me. But they have a disdain for Hollywood, but they're social media content creators just like we are. But anyway, the Wayfarers parties have described the FAC as their most recent attempt to put all the evidence before the court and the public. Emphasis on in original. That is a damning concession given the lack of any actual evidence supporting any legally cognizable claim against Mr. Reynolds. The Wayfarer party's so-called receipts include annotated excerpts, many with heavy redactions made by some unidentified persons, of emails, text messages, videos, and photographs, such as large colored photographs comparing Mr. Reynolds' long hairstyle in a movie with Mr. Baldoni's long hairstyle at some point in his real life. But the FAC is a pleading, not a gossip rag, and these so-called receipts fail to establish the requisite element of a single one of the many causes of action alleged against Mr. Reynolds. The Wayfarer parties attempt, but fail, to assert 6 causes of action as to Mr. Reynolds. each fails to plead facts sufficient to establish a prima facie case as a matter of law. For example, the plaintiffs collectively assert a claim for defamation without pleading a single complete statement or identifying the time or place of such statements, nor can they because no such defamatory statement exists. Further, the entirety of plaintiff's defamation claim appears to be based on 2 times that Mr. Reynolds allegedly called Mr. Baldoni a quote predator. But the FAC alleges no plausible facts that suggest Mr. Reynolds did not believe this comment to be true. Instead, the relevant FAC allegations suggest that Mr. Reynolds genuinely, perhaps passionately, believes that Mr. Baldoni's behavior is reflective of a predator. Even if the FAC plausibly alleged that Mr. Reynolds called Mr. Baldoni a predator while believing the opposite, which it does not, the law establishes that calling someone a predator amounts to constitutionally protected opinion. And the FAC's thin-skinned outrage over a movie character. Now, if you're not familiar with this movie character that he's talking about, he is talking about the character of Nice Pool in Deadpool and Wolverine. And if you're not familiar with Marvel, it is my understanding that Deadpool is not an iteration of Deadpool either way, because there's like Lady Pool and Dog Pool and I'm just a cat pool, whatever. But there is no Nice Pool. This is a character that was written by Ryan Reynolds, and that character appears to be mocking Justin Baldoni, and the public has come to that conclusion. Number one, because that character was wearing a man bun, and Justin Baldoni has been wearing man buns, from what I understand, for forever. Number two, he talked about, oh, I identify as a feminist. Justin Baldoni has made several statements that he identified as a feminist. The third thing in that movie that was mentioned in regards to Nice Pool is something about an intimate coordinator. There was no reason, there is nothing in Deadpool and Wolverine that would make you say the words intimate coordinator. There wasn't a movie that was needing an intimate coordinator, because I don't remember if there was any scenes that required an intimate coordinator. And also, the character Nice Pool was unalived by Lady Pool, who was voiced by Blake Lively, and he was unalived in front of a flower shop. Now, where would they get that from? Let's continue. The satirical, quote, woke Nice Pool does not even pretend to be tied to any actual legal claims. Instead, it falls into the FAC's general allegation of, quote, hurt feelings, which in reality is nothing more than a desperate effort to advance the same curated bully image that the Wayfarer parties created and disseminate in the retaliation campaign they launched against Miss Lively in August of 2024. And I don't know why I seem to be wanting to read this in how I have heard Ryan Reynolds speak, but it seems like his hands was all in this as well. So basically, it sounds like what they're saying is he don't have anything to do with it. They're just going on by the fact that the social media and the public is talking about that character of Nice Pool, and everybody has kind of figured, basically, I'm just saying in my words, they've kind of figured out that I may or may not have been mocking him, but there's nothing wrong with me mocking him. We're public figures. I can mock him all along. But see, it's him. If he wasn't doing this retaliatory taking this retaliatory position, I wouldn't be in this position. And they need to get me out of this. I don't need to be in this. All the other claims fail for similar reasons. The Wayfarer parties say that Mr. Reynolds extorted them, but fail to allege that he received any money or property. They claim he interfered with the contract without identifying what that contract is, what provisions were allegedly breached, or even which of them were parties to it. They assert $400 million in damages without explaining anything about who suffered that loss, in what proportion, as a result of which claims, or what proximately caused such losses. The FAC is long on hyperbole, prose, and claims, but devoid of any facts necessary to state ones recognized by law. It is, in essence, a burn book filled with grievances, not the burn book, attempting to shame Mr. Reynolds for being the kind of man who is confident enough to listen to the woman in his life and to hold her anguish and actually stand with her. The FAC is, in sum, a textbook retaliatory slap suit and should be dismissed with prejudice. Oh, let's get into the background. The Wayfarer parties have asserted a grab bag of claims against Mr. Reynolds in their FAC, including civil extortion claim, defamation, false light, invasion of privacy, intentional interference with contractual relations, intentional interference with prospective economic advantage. At 4 and 5 together, intentional interference claims, negligent interference with prospective economic advantage. The Wayfarer parties claim that they have suffered no less than $400 million in compensatory damages, plus mental pain and anguish, and severe and serious emotional distress, not to mention hurt feelings. I'm wondering how many times we're going to hear the word hurt feelings within this lawsuit, within this dismissal. Motion to dismiss. For what they posit, they deserve additional compensation. FAC prayer for relief. Despite its length, the FAC alleges only a few isolated acts by Mr. Reynolds. With respect to the defamation claim, the FAC does not plead a single complete statement published by Mr. Reynolds. The only hint about the purported statements that are alleged to form the basis of the defamation claim is followed as an assertion. Give me one moment. And while I'm doing this, will y'all please hit that like button for me? I really appreciate it. All right. Sorry about that. Let's look and see what he said. The only hint about the purported statements that are alleged to form the basis of the defamation claim is as follows. Is the following assertion in 325. The Lively parties made one or more statements to persons other than the Wayfarer parties, including without limitation to the New York Times, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively and others, and that the Wayfarer parties retaliated against Lively and others for reporting the alleged misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Only 2 allegations in the FAC even generously match that description with respect to statement purportedly published by Mr. Reynolds. First statement, her publicist, Leslie Sloan, went so far as to propagate malicious stories portraying Baldoni as a SA predator, a term Lively husband Ryan Reynolds also used to describe Baldoni when he called Baldoni's own agent. Then they have the agent statement. Baldoni, the second purported published respectfully for Mr. Reynolds was Baldoni's letter received word. Baldoni later received word that during the premiere of his movie Deadpool and Wolverine, Reynolds approached Baldoni's agents, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a predator, a phrase that uncoincidentally later appeared in the press, and at a later date demanded that the agent drop Baldoni. All emphasis added together equals the predator statement. Apart from these two statements, the totality of the FAC's allegation against Mr. Reynolds are that Mr. Reynolds demanded that Wayfair parties publicly apologize for so-called mistakes during production of the film, was present during a meeting at an apartment that he shares with Miss Lively. And he never says my wife, Miss Lively. I think he said that one time about being a protective partner. I don't think he's called her his wife. And that's fine. I'm just saying. Apartment that he shares with Miss Lively, which he praised Miss Lively's version of a scene in Mr. Baldoni's present, allegedly contributed some writing of his own to the script. Your wife said you did that. Your wife was the one that said that, and she spoke to a reporter to tell them that. So you need to talk with Blake about that. Admonished Mr. Baldoni for asking about Miss Lively's weight and demanded a scene be removed from the film. Attended a meeting with Miss Lively to address her allegations of SH on the set and demanded that Mr. Baldoni apologize for his conduct. Unfollowed Mr. Baldoni on social media and included the Nicepool character in Deadpool and Wolverine that the FAC alleges was meant to satirize Mr. Baldoni's person as a woke feminist. Y'all get so pissed off with, and I don't mean no harm, and if anybody in here is reading this, and I don't mean harm, but I just get real upset when I hear white media, white entertainers, or political pundits, or anybody using that word, and they're using it incorrectly, and it's a buzzword to mean either you are supportive of women or you are supportive of minorities, black folk in particular. That bothers me because you're not using it correctly. In reviewing the legal standard, in reviewing a motion to dismiss under federal Fed RCV CIVP 12B6, and here's another 12B6 that they're doing as well. So I've seen this 12B6 be used. I think Leslie Sloan is using it because she wants to get out of here. And meanwhile, it looks like he's throwing Leslie Sloan under the bus. But for Leslie Sloan, I see it for the New York Times, and UMG is using it to get out of to just have their to have their case against Drake dismissed. Hello. Thank you so much for coming, Blue Queen. The court accepts all factual allegations as true and draws all reasonable inference in the plaintiff's favor. However, this requirement is inapplicable to legal conclusions, and threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. A complaint must offer more than labels and conclusion, or a formulaic recitation of the element of a cause of action, or naked assertions devoid of further factual enhancement in order to survive dismissal. The argument. The claims against Mr. Reynolds fail under both New York and California law. While the Wayfair parties appear to agree with Ms. Lively that California applies to the allegation in the case she filed, that does not answer what law applies to the Wayfair parties' claims against Mr. Reynolds. The choice of law may be vary by defendant and also by specific claims, even against the same party. Under both California and New York conflict rules, a different determination properly is made for each defendant and each claim. To the extent that there is no conflict between California and New York law with respect to the Wayfarers Party's claims against Mr. Reynolds, the court may simply apply New York law. To the extent that there is a conflict, as there may be with respect to the extortion, false light, and negligent interference claim, New York law applies to the claims against Mr. Reynolds because New York is the jurisdiction having the greatest interest in those claims, given the way the Wayfarer parties pled the claim against him in the FAC. The FAC's allegation as to Mr. Reynolds focused solely on conduct that occurred in New York while he resided in that state. Let's see. Whereas here, Mr. Reynolds alleged torts are conduct regulating rather than loss allocating, the law of the state where the conduct occurred will typically apply. Further, unlike Miss Lively, Mr. Reynolds was never an employee of Wayfarer Studios, nor did Mr. Reynolds ever have, unlike Miss Lively, any contractual relationship with the Wayfarer parties, and therefore no contractual choice of law provision to apply. As set forth below, however, each of the claims fall under both New York and California law, and therefore the FAC should be dismissed with prejudice against Mr. Reynolds. The court should dismiss all of the 6 causes of action as to Mr. Reynolds with prejudice. A. The FAC fails to state a claim. The FAC fails to state a claim for defamation against Mr. Reynolds. The defamation claim fails as a matter of law. It is fatally deficient because the FAC does not identify a single allegedly defamatory statement published by Mr. Reynolds, including either of the predator statements. Moreover, to state a claim for slander, a plaintiff must plead a defamatory statement of fact that is false, published to a third party of a concerning the that whole thing is just in my mouth. Moreover, to state a claim for slander, a plaintiff must plead a defamatory statement of fact that is false, published to a third party of and concerning the plaintiff, made with the applicable levels of fault in the part of the speaker. Now we're going to read this footnote at the bottom. It says Mr. Reynolds joins the argument in the Sloan and New York Times motions to dismiss that the FAC must be dismissed for impermissible group pleadings. So everybody So everybody's leaving Blake. Everybody is deciding to leave Blake. Isn't that something? Everybody's leaving the Sloan, the New York Times, Ryan Reynolds, either causing special harm or constituting slander per se, and not protected by privilege. The Wayfarer complaint does not sufficiently identify any defamatory statements published by Mr. Reynolds. The court should dismiss the defamation claim as to Mr. Reynolds because the FAC does not include allegations specific enough to afford him sufficient notice of the communications complained of to enable him to defend himself. Interesting. As this court has noted, it is only by pleading the substance of the purported communications that a defendant can challenge, and upon a motion, the court can determine the essential elements of a defamation claim under New York law, including whether the statement was false, whether it was capable of defamatory meaning, and whether it was of a concerning the plaintiff. The FAC fails to sufficiently plead the substance of the predator statements, which are the only ones relevant to the defamation claim as to Mr. Reynolds. As to the agent statement, the FAC does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversations during which he purportedly uttered the agent statement, stating only that Mr. Reynolds used the term predator to describe Mr. Baldoni during a phone call with Mr. Baldoni's agent. The absence of these words details makes it impossible, for example, to determine whether this statement falls within the applicable 1-year statute of limitations, both New York and California law for defamation. Falls under the 1-year statute. All that happened in December. He lost his job and everything in December. Keep reading. The sole allegation as to the executive statements provide only slightly more detail, namely that Mr. Reynolds and an unnamed executive at WME had a conversation during a movie premiere about Mr. Reynolds. Deep disdain for Baldoni, suggesting the agency was working with a predator. The FAC does not allege what precise term Mr. Reynolds used in this allegation, in this alleged suggestion. The sentence in which he allegedly suggested it, or any information about the context of the conversation. Other than that, one of them was about how much Mr. Reynolds disliked him for having harassed his wife. First time I've seen that word. Such bare bones pleadings fail to satisfy Rule A and warrant dismissal of a slander claim. Two, the predator statements are not defamatory because they are constitutionally protected opinion. The predator statements are unactionable opinion. As a threshold matter, because there is no such thing as a false idea. Instead, courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory. The predator statement constitutes unactionable opinion because they have no precise meaning, are not capable of being objectively categorized as true or false, and are merely general reflections of a speaker's viewpoint. As another court in this district has explained, courts have recognized that words like scum, predators, greedy, crooks, and criminals preying on the culture are vague, imprecise statements of hyperbole considered non-actionable opinion. I could see if someone says, "Oh, well, you are such a dog." That doesn't seem reasonable. But to say someone is a SA predator, someone reasonable for me to assume that there is something illegal about that. I don't know about that. That again, if my attorney people, y'all let me know down in the comments. But because usually when you hear predator, you think of someone doing something illegal. You remember that show? Do you all remember that show, Catch a Predator? And it was designed to catch people who were contacting and having illegal conversations with minors in the pursuit of having relations with them, knowing that they were minors. Because calling him like that, calling him this name with someone who has the power to give or take away or void his contract as being a talent agent, that's actionable, in my opinion. I don't know about the law, but that seems actionable to me. And that doesn't seem like an opinion. Use of colorful language such as predator, victimize, or face of evil are not actionable in and of themselves. True, but if you're saying that to someone who has the power to give and take away something that's quite meaningful or very necessary to a person, I think that falls up under that. While Mr. Baldoni may not appreciate being called a predator, those hurt feelings do not give rise to legal claims because name calling does not reflect a fact but a non-verifiable view. These First Amendment principles ought to be obvious to and even celebrated by a group of litigants who have spent most of the past few months calling Mr. Reynolds and his wife bullies and liars. Oops. Interesting, and if you have just joined me at the thing that I said at the top of the hour, what's interesting is that one of the lawyers for this case and Melissa Nathan are also representing Drake. And this language that I'm seeing in this filing is the same language that UMG was using against Drake as to having this case dismissed. It's quite interesting to be a lawyer, that you can represent people on both sides of an argument, two separate clients, but on both sides of the argument at the same doggone time, to really tell you the truth. Excuse me. The FAC fails to plead any facts indicating that Mr. Reynolds' statement could be reasonably understood to have been an assertion of fact capable of being proven false rather than a pure opinion that is not actionable under the laws of New York. But she's suing him for that. She's suing him for harassing her. And the word predator has a lot of adjectives to it, but still, this is partly what he's being sued for. The FAC fails to plead any facts indicating that Mr. Reynolds' statement could be reasonably understood to have been an assertion of fact capable of being proven false rather than a pure opinion that is not actionable under the law of New York. While the FAC fails to provide sufficient details about the predator statement, which alone is ground for dismissal, the limited context it does provide, I'm hoping they meant to say mitigates, maybe that's what they meant, mitigates in the favor of a finding that they are assertions of opinion. The FAC alleges that Mr. Reynolds made the predator statement during a phone conversation with Mr. Baldoni's agent and at a movie premiere during a conversation with a WME executive during which Mr. Reynolds was expressing his deep disdain for Mr. Baldoni, which is utterly fatal under the opinion doctrine because it is plainly reflective of Mr. Reynolds' unabashed negative opinion of Mr. Baldoni's character. Mr. Reynolds has a First Amendment right to hold Mr. Baldoni or any man who Mr. Reynolds believes sexually harassed his wife in deep disdain. And the FAC does not allege any plausible fact that would remotely suggest, let alone establish, that anyone interpreted Mr. Reynolds' statement as a reflecting anything other than his genuinely held belief about Mr. Baldoni's character. The court should dismiss the defamation claim as to Mr. Reynolds with prejudice because the predator statements are expressions of opinion that deserve absolute protection by law. If the predator statements are not opinion, they are substantially true. Even if the predator statements were verifiable as fact, they are not actionable as defamation because they are substantially true. The Second Circuit has held that whether statements are substantially true is appropriate for resolution in a motion to dismiss. Because falsity is an element of the New York's defamation tort, and falsities refer to material not substantially true, the complaint in this case must plead facts that, if proven, it would establish that the defendant's statements were not substantially true. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. When the truth is so near to the facts as published that fine and shaded distinction must be drawn and words pressed out of their ordinary usage to sustain a charge of libel, no legal harm has been done. It is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary is to demonstrate that the gist or substance of the challenged statements be true. The FAC includes numerous references to the conduct that a reasonable observer could well consider predatory. In particular, the FAC relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast, Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's book. Relying on statements made on Mr. Baldoni's podcast, see also, whatever that is. Those materials, which anyone who knows about Mr. Baldoni would be familiar, includes numerous admissions to behavior that could reasonably be described as predatory. And then they go down here to state, okay. They even quote him here, Justin Baldoni. It says here, this is them quoting Justin Baldoni. I am sure I have crossed boundaries and lines in my teens and 20s, not even thinking about it simply because of the porn I was consuming. Let's see. Admitting to relaying distributor concerns and widespread social media criticisms about Miss Lively's appearance, admitting to suggesting Miss Lively character, quote, orgasm during the scene, admitting to telling Miss Lively that the onesie she was wearing underneath her jacket was sexy, admitting to casting his friend as the obstetrician in the birth scene where he would be in close proximity to her nude genitalia, admitted to asking Mr. Heath to show Miss Lively his wife's post-home birth video, no denying of biting and sucking the lip when script only states kissing scene. The Man Enough podcast, Jamie Camel changing the narrative, YouTube, this is their recording a YouTube video at 38 minutes 42 seconds, 38 minutes 52 seconds on March 14th, 2022. I grew up and I had an addiction to porn. I was introduced to porn at 10 years old, formed those newer pathways in my brain, and it caused me to see the world very differently. A Life of Greatness, Justin Baldoni, The Power of Being Enough, Apple Podcasts at 45 minutes, 45 seconds, and 46 minutes to 16 seconds, July 26, 2021. And for me, it was really tricky because I believe there is a link between our culture and porn culture. I'm not calling out the porn industry. I'm calling out my relation to it. But I do believe that especially the porn that young boys are watching is very violent. And because no one ever sits us down and teaches us about consent, we learn it through porn. Interesting. The Man Enough podcast, Joy DeGruy Access to Respect. And they're going to be at 28 minutes and 50 seconds, 29 minutes and 4 seconds. And this was published on October 25th, 2021. You're right. As a Black man, or you as a woman, have had to put up with a lot of shit from people that look like me, and or from me, your entire life. And again, it could be laundry, or it could be microaggressions for racism or sexism, whatever it is. I've done all of them. Justin Baldoni, Man Enough, uh undefining my masculinity, quotes, I wanted as a man to claim her publicly, as on some level I knew it would make me feel more like a man. While it is unclear what predator means to an average listener, y'all excuse me. It is quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statements and the very behavior which Mr. Baldoni has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to pornography, as well as openly describing his distorted conception of consent in a sexual relationship. Where Were this case to go to trial, it would be Mr. Baldoni's burden to prove the factual falsity of the supposed allegation that he is a predator. But the law offers no principled basis for a jury to distinguish that label from Mr. Baldoni's descriptions of his own behavior. Let's see. Finding substantial truth, where an article called Plaintiff an Adulterer, because an average reader would understand that term to include the admitted truth that he was a man who unabashedly committed adultery for 13 of the last 17 years, and whose adulterous behavior ended only because his wife ultimately divorced him. Okay, I was reading something in the case law. That's not what I wanted to do. Okay. I think my P's and my were a little too loud in ear for your ear. I know it's loud in mine. So let's see if this buffers that. It would be perverse to permit Mr. Baldoni to build an entire brand, complete with a podcast, TED Talk, and books, off of his confessions of repeatedly mistreating women, only to turn around and sue Mr. Reynolds for $400 million for simply pointing out in private what Mr. Baldoni had bragged about in public. In light of Mr. Baldoni's own public admission of what the court can take judicial notice, the substantial truth doctrine requires dismissal of Mr. Baldoni's defamation claim to Mr. Reynolds. So he's basically saying Mr. Justin Baldoni has sat on his podcast and has talked ad nauseum about his behaviors, about his knowledge of consent, about any of those different things, and that he has spoken about the things that he did that a reasonable person would conclude that at one time he had predatory instincts, or he could have been a predator. And Ryan is saying, I made a statement about this to his agent and to someone, an executive at WME, and I made those statements because I was upset, appalled that the things that my wife said he did. So we can understand that. The FAC fails to plead special damages. Dismissal of the defamation claim is warranted because the FAC does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with sufficient sufficient particularity to identify actual losses. This particularity required requirement is strictly applied, as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity. Far from fully and accurately identifying any harm that flowed directly from the injury to reputation caused by the predator statement, the FAC generally claims at least 400 million in compensatory damages without explaining what amount, if any, of that astronomical sum allegedly was suffered by Mr. Baldoni versus any of the other Wayfarer parties, or otherwise caused by the predator statement. Mm, mm, mm. With FAC prayer for relief, compensatory damages, including consequential damages, lost wages, earnings, and all other sums of money, together with interest on those sum amounts, in an amount to be proven at trial, but in no event less than $400 million. The court should strictly apply the particularity requirements and dismiss the defamation claim for failure to allege special damages with the requisite degree of specificity. The FAC fails to plead facts demonstrating actual malice. As a public figure, Mr. Baldoni must plead facts demonstrating that Mr. Reynolds uttered the predatory statements with actual malice. In other words, that Mr. Reynolds, in fact, entertained serious doubts as to the truth of his publication. The FAC conclusory assertion that the lively parties, defined to include Mr. Reynolds, knew the statements were false or had serious doubts about the truth of the statements, is threadbare recitation of the legal element that is insufficient to sustain the law's heavy burden on defamation. It would be inconsistent with the FAC to find that Mr. Reynolds uttered the predator statement with actual malice. Indeed, there is not a single plausible factual allegation from which a jury could conclude that Mr. Reynolds does not believe Mr. Baldoni to be a predator. To the contrary, the FAC alleges that Mr. Reynolds took steps consistent with believing his wife's allegation, including demanding an apology from Mr. Baldoni and mocking Mr. Baldoni's quote woke feminist facade in Deadpool and Wolverine, not to mention Mr. Baldoni's own public admissions about his past conduct, the deep disdain that the FAC alleges Mr. Reynolds feels towards Mr. Baldoni, concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni and thus defeats a finding of actual malice. Let me go back up here because is he? To the contrary, the FAC alleges that Mr. Reynolds took steps consistent with believing his wife's allegation, including demanding an apology, mocking Mr. So he admits to mocking him. Is that what I'm reading? Including, to the contrary, the FAC alleges that Mr. Reynolds took steps consistent with believing his wife's allegations, okay, including demanding an apology and mocking Mr. Baldoni's woke feminist facade in Deadpool and Wolverine, not to mention Mr. Baldoni's own public admissions about his past conduct. The deep disdain that the FAC alleges Mr. Reynolds feels towards Mr. Baldoni concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni and thus defeats a finding of malice. Well, at least we see that he admitted that he did mock him in Deadpool and Wolverine. We are reasonable people and we saw that. All right. The predator statements refer solely to Mr. Baldoni and not any of the 6 other Wayfair parties. To the extent that the FAC intends to assert the defamation claim on behalf of any defendant other than Mr. Baldoni, it requires dismissal because the predator statements are not of and concerning any of them. This what makes it seem difficult to me when they put all this stuff in there, because you have to be it's sounding like you have to be real specific about whose charge is what thing is doing for what charge. Whew. The Wayfarer complaint fails to state a claim of false light. The FAC fails to state a claim of false light as a matter of law under either New York or California law. There is no tort or of false light invasion of privacy under New York law, and the court need not engage in any further analysis in order to dismiss such claim. While California law recognizes claim of false light, dismissal also is required when, as here, the claim for false light invasion of privacy is duplicative of a defamation claim. While the FAC false light claim suffers from the same fatal lack of specificity described above, which alone requires dismissal, it also fails because it appears to rely entirely on the alleged public disclosure of information on which the defamation claim is based. Finally, even if all of that were not dispositive, the false light claim fails as a matter of law for all of the same reasons the defamation claim cannot survive dismissal. Whether applying New York or California law, the court should dismiss the FAC false light claim. The Wayfarer complaint fails to state a claim for civil extortion. The civil extortion claim against Mr. Reynolds must be dismissed because New York law does not recognize extortion as a tort or as any private right of action. Similarly, although California federal courts have divided over whether California recognizes a civil cause of action for extortion, the most that California state courts have recognized under the heading of civil extortion is a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution. There, the threat of prosecution is made with the knowledge of the falsity of the claim. Because that cause of action is a form of fraud, it must be pleaded with particularity under Rule 9b. The FAC is devoid of any allegation, much less particularized allegations, that Mr. Reynolds obtained any money or property from any of the Wayfarer defendants or made any wrongful threat of prosecution, much less with the knowledge of the falsity of the claim. And the same is true using the borrowed elements of criminal extortion. The FAC fails to allege that Mr. Reynolds either obtained any property or consideration from any Wayfarer defendant, because of course he did not, or did so through a wrongful use of force and fear. The intentional interference claim must be dismissed. Hold on. The tortious interference claims are duplicative of the defamation claim. As an initial matter, each of the tortious interference claim must be dismissed as duplicative and the defamation duplicative of the defamation claim. New York law considers claims sounding in tort to be defamation claims where those causes of action seek damages only for injury to reputation, or whether the entire injury complained of by plaintiff flows from the effect on his reputation. Whether Mr. Reynolds' alleged statement to WME are actionable in light of their claims, effect on Mr. Baldoni's reputation must fall as well under the pleading requirements for defamation. Nonetheless, each claim fails on its own term as well. The FAC fails to state a claim for intentional interference with contract. whether under New York law or California law. Intentional interference with contractual relation requires that the plaintiff allege one, the existence of a valid contract between plaintiff and a third party, two, defendant's knowledge of said contract, three, defendant's intentional procurement of the third party's breach of the contract without justification, four, actual breach of the contract, and five, damages resulting from the breach. To survive a motion to dismiss, a plaintiff must specifically plead the existence of a valid contract and must identify what provisions of the contract were breached as a result of the act's issue. Furthermore, because a claim for tortious interference requires a showing of breach, contracts that are terminable at will generally cannot provide the basis for such a claim. A plaintiff must also plead specific allegations of the defendant's knowledge of the contract, including some knowledge of the terms and conditions. It says here that the FAC fails each of these requirements. The sole contract alleged in the complaint is a contract between the Wayfair parties and William Morris Endeavor. But the FAC does not allege any details about the contract, including which parties it allegedly bound. Surely not all 7 Wayfair parties were party to it. What the contract terms were or what provisions were allegedly breached. Strikingly, throughout the entire FAC, there is not a single allegation that WME breached its contract with any Wayfair party, much less a description or quotation of a contractual term allegedly breached. Instead, the Wayfair parties allege solely that upon information and belief, Miss Lively and Mr. Reynolds induced WME to cease performing under its contract. But the cessation of performance is not the same thing as a breach of contract, and the Wayfair parties who have alleged the existence of this contract and are presumably in possession of its full terms have utterly failed after multiple tries, hundreds of pages, more media interviews than can be counted, and a publicly launched website to identify any actual contractual provisions that they claim WME breached when it allegedly ceased performance. And it continues to go on about the FAC failed to state a claim for intentional interference. We won't read that. They failed to allege any damages. A Wayfair complaint fails to allege the conspiracy liability. And they go on and on and on. And they want their attorney fees paid by the anti-SLAPP statute because they're believing that once they dismiss this case via that, coming up with just putting up cases just to put up cases, they're saying that he should pay Mr. Reynolds attorney's fees. All right, let's get into this Exhibit A. The court should strike Exhibit A to the Wayfair complaint or at a minimum disregard it. Mr. Reynolds joins the argument in the Sloan MTD, moving the court to strike the FAC Exhibit A pursuant to Rule 12. Exhibit A, as this court has recognized, permitting a party to satisfy its pleading requirements by attaching documents other than instruments to the complaint, would do considerable damage to Rule 8 notice requirement, including by requiring a defendant to hunt around voluminous materials to figure out what the plaintiff alleges is relevant and support its claim and what is extraneous. Even if the court does not strike Exhibit A, it cannot properly consider it to evaluate whether the FAC sufficiently states a claim. In conclusion, all claims against Mr. Reynolds should be dismissed with prejudice and without leave to amend, and the court should award Mr. Reynolds his costs, including attorney fees incurred as a result of the consolidated action. And again, let's count the attorneys. You're paying 1, 2, 3. 1, 2, 3, 4. No, One, two, three, four, five, six, 7, 8 attorneys. We have to count to see how many attorneys Blake Lively has, because this is 8 just for him. All right. So Ryan Reynolds says, y'all, he does not want to be in this lawsuit anymore. He thought his little joke at SNL, he thought his man next door persona was good enough. And he wanted you all to believe that. And he's saying, wait a minute, hold up. These people are not believing that, because regardless of what we think, anybody and everybody who lives in the state of New York has the ability to be a juror on this case. And also, he doesn't want you having to go through any of his records or any of those things, because he don't know what you're going to pull up and then try to use against him. That's 2. Number 3, he says he said what he said. He believes that Justin Baldoni is a predator, not just by the words that he spoke, but the words that Justin Baldoni spoke on his podcast. He thoroughly admits, according to what I saw, and y'all let me know if I read that wrong, but he thoroughly admits of mocking him in Deadpool and Wolverine. Now, this is interesting because they're going to bring, if the judge says, it's still going to go through, they may be bringing Marvel into all of this. Child. All of this is a mess. But I just wanted to come on here and to bring you this information, because Ryan Reynolds says, stop this. Ooh, it's like he was saying, and I am telling you, I am going. I don't want to be part of this no more. Ooh, he's pulling the Dream Girls and effing Dream Girls. He's saying he's not. She says I'm not going. He says I am going. I'm getting out of this because this is messing with my money. This is messing with my reputation. My wife was the one that put this up. Y'all deal with her. Y'all ain't got to deal with me. You all make sure y'all deal with her. So that's basically what we're reading in regards to this particular lawsuit with Ryan Reynolds. Ryan Reynolds is wanting to be dismissed from this lawsuit. Also, shout out to Bohemian Diva. We did go over part of her video, which let us know that Stephanie McNeil is 3 degrees of separation from Ryan Reynolds. Her husband produces a show called what was it? Selling somebody. Whoever that somebody is sold Bradley Cooper's home, and Bradley Cooper is a friend of Ryan Reynolds. And since her piece was heavily Blake Lively laden, that we could see now the reason why she wrote that article, and the reason why in my opinion, why she was going off on the content creators out here on YouTube, TikTok, Instagram, wherever there's social media, Twitter, whatever social media handle has. She had a little disdain for all of that, and now we see why she's had this disdain. She probably thought she was doing her friends. She thought she was doing her husband and his cast, his employee who on that reality show. She thought he was doing everybody a solid, but we see now that it probably has backfired only in public opinion. And then again, the thing about the public, what we have to discern is that these people in New York are watching all of this stuff. And that's where this the Southern District of New York is, and these are the people who are going to be sitting on juries. And they're trying to make sure that they can get as much positive, either get dismissed from the case or get as much positivity out here in the public, so they won't look so bad, or whatever. They'll look better or they won't look bad. So that is the motion to dismissal for Ryan Reynolds and Ryan Reynolds only. So far, Leslie Sloan has put in a motion for dismissal. The New York Times has put in a motion of dismissal, and Ryan Reynolds have put in a motion of dismissal. So that leaves on Blake Lively's team, if all three of them get their motion to dismiss granted, that leaves Blake Lively out here. So we'll see. Now, I think Justin Baldoni's team has a time to answer. So it looks like, and I don't know, is it just me? But it seems like they want to know what playbook Justin Baldoni has, because they want them to be very extremely specific. But remember, they have not gone through discovery or anything yet, so they want them to be real specific about what they're trying to get at. And so we'll see. What do you all think? What do you all think down in the chat? Do you think that Leslie Sloan, the New York Times, and now Ryan Reynolds, in reading and hearing about these motions to dismiss, do you think the judge is going to dismiss, or is he going to do one of those dismiss some but not all type of deals? Because with all these motions of dismissal and with all of these things that the judge is going to have to look at and research, y'all think they're going to make this March date? Because it seems like just those 3 dismissals alone seem like a lot. I don't know. They got this Judge Lyman is working his behind off. They've got him pulling out law books and textbooks from everywhere to work this case. Again, y'all let me know in the comments what y'all think of this case. This case has so many moving parts, so much information comes out week by week. That is why I was doing the weekly show. This is considered to be my weekly show because I usually do them in the daytime or earlier in the evening. So this is the weekly show. But Ryan Reynolds, in conclusion, he says he wants out. And he wants to be out, and he's asking the judge to dismiss this case, along with Leslie Sloan, who is the PR person, and along with the New York Times. We are going to see. New York Times was first, Leslie Sloan was first at bat. I don't know if that has been put on the plate, or has the judge written an order for that. I have not seen that yet, or haven't heard anybody talk about that yet. And we know that the New York Times has placed theirs in. So there's 3 in right now, and we're going to see what the judge says. So in the next couple of weeks, we'll probably be waiting for those types of things. I think what's going to happen is that Justin Baldoni and his team are going to look at these complaints, and they may possibly amend. They may possibly amend their complaint. They may get to the judge and ask him, can they amend their complaint? We'll see. All right, people. We do this every week. Please like, comment, and subscribe. Please share this video if you care. Y'all, please tell a friend, tell a kin, tell your coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people, bye-bye. Ryan says he's got to go.